We're going to talk about elder mediation and what's so complicated about it. Some of you, I think, have been trained in elder mediation already. Yes? Some? Okay, quite a few of you. And some of you are elder law, are attorneys that handle elder cases. So feel free to chime in with any of your experiences or questions. And some of this is a presentation that I've done in other states, so some of this may seem familiar to you, and the words I've used on the slides are a little bit different than some of the words we use in Michigan for some of these things, but I'll try to keep up with Michiganders. That was a perfect word to start with, Sally, because I just often on these elder cases where at least the ones that are coming from the court, we're talking about a guardianship or a conservatorship issue. A guardianship is when a person files, anybody can file a petition for guardianship. And alleging that a person, usually an older person, although it could be a younger person who is disabled in some way, is unable to take care of their personal life or their finances. So a conservatorship is when, and sometimes known as a financial guardian on my slides, is when a person is alleged to be unable to take care of their financial business, and a guardianship is when a person is alleged to not be able to take care of their personal life, and sometimes people need both. So it used to be back in the not so always good old days that one of the criteria in the statutes was for getting a guardianship over an older person was old. So, and old is defined usually by anyone over, it depends on whose scale you're looking at, but over 55 or 60. So several of us in this room could have been. So a lot of work.
Because you can get a guardianship just because someone was old.
That was one of the criteria in the statute, was being old.
Don't tell my sons this.
Well, the good news is that there's been a lot of work done on due process and changing the criteria in the statute, so that is no longer on its own a reason to get a guardianship over someone. Due process means that also the change in the laws means that the person that someone has petitioned to be a guardian over is interviewed, consulted, brought in, has a right to come into court and contest that, which wasn't always the case back in the day either. So it was really easy if you were old and to get a guardianship over you, because there was no due process either in the laws. So things have changed. That being said, the Center for Social Gerontology here in Ann Arbor did a study many years ago. It was a nationwide study, so they weren't just looking at Ann Arbor. But guardianship hearings on average take about 5 minutes nationwide. So if nobody is contesting it, it can be a pretty smooth and fast process. When you get cases referred, and good, Carmen's here, so she can talk, she does the intake on the guardianship cases. Good morning. When cases come to mediation, it's often because someone is contesting it when it comes from the court. We talk about elder cases also, and so I distinguish between guardianship and elder cases. Elder cases are cases where there isn't necessarily a petition over a person for guardianship, but many of the same issues are going on in those cases. They just haven't gotten to the point where they're filing for a guardianship yet necessarily. But it's very often what's at the heart of these cases are families trying to make decisions about how to care for a person who is failing in some way. Failing is a very nice word. So what happens, just a real quick overview, and attorneys jump in if you want to add something to this, but what happens when a petition is filed in the court, alleging that someone needs a guardian or a conservator, the guardian ad litem is appointed, and it's important for all of us as mediators to understand what the job of a guardian ad litem is. The guardian ad litem is there to look out for the best interest of that person, not necessarily what that person wants, but what the guardian ad litem believes that person needs. And so the guardian ad litem goes and interviews the person, makes an investigation, and makes a report to the court recommending whether or not there should be a guardian. In the guardian ad litem statute in Michigan, we are one of, I think, only 2 states, unless that's changed in the last couple of years, that requires the guardian ad litem to consider whether mediation would be helpful if there is a conflict going on in the family and on the case, that mediation would be helpful so that they can recommend it to the court. The guardian ad litem also needs to, when they interview the respondent, the person is called, for whom the petition is over, when they interview that person, they are supposed to, if they can, determine whether that person agrees with the fact that, with the guardian ad litem's recommendation. If that person is in disagreement, the guardian ad litem needs to go and tell the court that, so that an attorney can be appointed who will look out for who will advocate for what that person actually wants. So it's important for us as mediators to know the difference, that if we have an attorney or a guardian ad litem in the mediation, who are they speaking for? Are they speaking for what they think is in this person's best interest? And is the person in agreement with that? Or are they an attorney that's advocating for what that person wants? So, another thing in the law that is required is that the court and the guardian ad litem consider less restrictive alternatives to guardianship or conservatorship. And I'm not going to go through this all the way, but this is just to show that a conservator or a guardian comes at a time when a person does not have the mental competence to set up another instrument. So if you have advanced directives already in place for a power of attorney or something like that, you need mental capacity to do that, and or a trust, then you may never need to have a conservator or a guardian. So what this it needs mental competence to set up column is probably the most interesting for our purposes today. If you're going to set up a power of attorney, you have to have mental capacity to do that. If you're going to set up a joint property arrangement or a trust, you need to have mental capacity to do that. So conservatorships and guardianships get to the court, and the court makes a decision on that when a person no longer has that capacity, and that's a court's determination.
Could you clarify the capacity issue? Because I know it's come up in many contexts for attorneys where the client seems to have capacity in some area, and there's poor judgment in another, and then the capacity, there's a diminishment of the capacity over a period of time. So does the court look at that? How is that addressed?
Often there's a medical report, an assessment that is done, an evaluation by a doctor, but the statute has specific criteria in it that will say what the court has to consider as far as making a determination. But usually there is. Those of you, is anybody here a probate attorney? Well, for some. Often, I think, and what I'm hesitant to say and what I'd like to check out with a probate attorney is it every time that a medical assessment is done? I don't know that. But it's very often there's a medical evaluation, particularly if there's any real question. Non-financial alternatives, so this is for guardianship. This is when a person is alleged to not be able to, maybe they already have a power of attorney for something specific, such as handling their finances, but all of a sudden they're wandering, they're leaving home, they're making poor decisions, risky decisions. It's starting to look like they can't care for themselves, but they're refusing to move from their home. often a guardian is then appointed to make those decisions for them. It's often a family member, and often the conflict in mediation is which family member should it be? And I guess this won't come as a huge surprise to anybody, but often there are issues of money among family members. Accusations that one family member is misusing funds, the person that has access to the funds perhaps on a joint checking account, things like that. So again, nominal competence is needed for a guardian. A court sets it up. A court also continues to monitor guardianships and conservatorships throughout. Every year, reports have to be made. But there are other things that people can set up: a power of attorney for health care, advanced directives, do not resuscitate, orders, someone to represent them. I'm sorry. Those are the two that require mental competence to set up that we can do now, all of us, for these things. So typical issues that come up in mediation on these cases, and regardless of whether this is a case that's coming from the court or this is a non-court case where it's just a family in turmoil and conflict, these are very often, this is usually a fairly complete list of what the issues are. Sometimes it's consumer issues. It's someone that, got scammed over the phone or got a bad deal somewhere or isn't paying their bills or whatever. But mostly it's things like health and medical care decision-making, financial decisions, where a person's going to live, are they going to move into a facility, are they going to live with a family member, can they continue to live on their own. Communication issues, not a surprise to mediators, that family members may not be communicating with one another effectively. Decision-making, who gets to make the decisions? If someone is beginning to have trouble making decisions, who should be the decision maker for that person? And how is that information going to be shared? Personal household care and maintenance. Safety, risk-taking, and autonomy. So autonomy is a very, very important concept in the law. As adults, this is different than minor guardianships, where usually the issues are for someone who does not have the right to make their own decisions anyway, right? A child. And it's usually issues about parenting time, child support, conflict between a guardian and a biological parent, authority to make healthcare decisions, things like that. When we're talking about an adult, we're talking about a person who, until a court decides otherwise, has full rights to make decisions for themselves. We call that autonomy. We are individuals who have the right to make our own decisions. And so that can really come into conflict as a person gets older. And we're talking about taking risks. So it's the issue about taking the keys away from an older person who's driving. That's taking away an awful lot of independence from a person. But is it safe for them to continue to drive? Is this a person who always made bad decisions? Who was always a bad driver? Who always took risks that we wouldn't take ourselves? Is this really a change in their personality? Or is it just maybe a little bit more dangerous because they're getting older? Family relationship issues. So blended families is a really big one, where there's a lot of conflict often. I used to think before I started doing these cases that blended families were a big issue when people remarried, when families and siblings and everybody tried to get along. It doesn't end. It goes on and on through people's lives very often. So you get to the point where someone is in a nursing home, a parent is in a nursing home, and one family takes over and won't let the other family come and visit, or inheritance issues, all those things. The lifestyle choices, that kind of is tied into what I was talking about, risk-taking and autonomy. Oh, let me go back to family relationships. New people in their lives that an older person has suddenly taken an interest in it's just some person they met in the park. Maybe it's a completely different kind of relationship. Maybe it is a heterosexual person who's now involved in a gay relationship at an old age. Maybe it is suddenly taking an interest in their caregiver and giving them money. All of those things come into conflict with children and families. So, needs of other family members and caregivers. It's not just the older person that we have to pay attention to in these mediations. I used to feel like, I used to sit there and I'd see family members talking and the older person just seemed perfectly fine to me and very sweet. And I could see the eye rolling going on around the table by everyone else there. And then when we had to do some caregiving in my family too, I realized what an exhausting job it is for caregivers. It is, I think, the hardest job in the world for people to try to take care of somebody who is unable to care for themselves any longer. It's very, very tough. And so the exhaustion of the caregivers around the table, so we're not just dealing with a person who may be losing their ability to make decisions, but we're dealing with all of the frustration, the guilt, the exhaustion that goes with being caregivers that may be present too. Guardianship and conservatorship, obviously. Issues that come up after the appointment of a guardian or a conservator. So the person who has a guardian may no longer like that guardian, may want a different guardian, or family members may think that the guardian's not doing a good job, and so they may want to remove the guardian or conservator and put someone else in it. Divorce. We just had a case in the peacemaking court where where it was elderly people in their 80s getting a divorce, and one of them needed a guardian at the same time, and the spouse, I think, had been acting as a guardian, but who should be a guardian? Estate. So cases of these family dynamics don't end with the death of a person. There's the estate to deal with afterwards, and sometimes there's a lot of money, sometimes there's not much money, sometimes the issue is over who's going to get the orange fur sofa or the lamp, or it was with me. Somebody was with me over at the court, and it was about a cookie jar they were talking about that they wanted out of the house. So, it can be over something big, it can be over something small. It's still that family conflict going on in the state matter.
One thing to add to that list is elder abuse, both verbal and physical.
Yep.
By adult children.
Yeah, that's one of the things that makes this different than some kinds of mediation. We have those exceptions to confidentiality in the confidentiality rule, the abuse and neglect of an older vulnerable adult or a child, or an imminent threat of harm, but these are the cases in which it may come up. And that's part of the training is sort of learning what elder abuse even looks like, and financial abuse, and neglect, and self-neglect in older adults. Self-neglect is not usually ever a reason to rule out mediating these cases, because it's really a person who's not taking their meds. It's a good thing to mediate about, not taking their meds, not taking care of themselves by other things. A really important thing for us to remember in mediating these cases is that while the family may think that the issue is whether this person needs a guardian or not, it's not an issue for mediation. That is a court, it's a legal determination. That's a determination that has to be made by the court under the criteria in the statute. So the question in mediation really is, if the court determines this person needs a guardian, who should that person be? And then the family can make a recommendation to the court as far as if they can all get on the same page, who they want in the family, who they're recommending to be the guardian. So that's something people get mixed up about. That's something judges get very nervous about. That why would if they don't know about mediation in these cases, why would I send this to mediation? This is for me to decide. So that's something that we need to be very clear about. The other thing that we need to do is determine whether we can really provide a process that accommodates the needs of all the parties, the exhausted caregiver, the person who may be failing in their memory or in their ability to make decisions. And it's important for us to remember that capacity is like a moving target for people. So anyone who has ever been around someone with dementia, you know that there's a very long continuum. It can start out with just forgetting a few things, forgetting a name, forgetting that you just something like a lot, forgetting that you just said something and repeating it again, or just being confused, all the way down to really not knowing where you are, who anybody is. So, and it can be a very quick progression, depending on the disease, or it can be a very slow progression. My mother has had dementia since 1997, and she's still herself in many ways. It's been a very, very slow progression. On the other hand, I've heard stories of people who, you know, within the span of a year or two have gone from one end of the spectrum to the other. So, and just because someone is leaving their keys in the oven, can't balance their checkbook, does not mean they don't have an opinion, and a consistent opinion on the things that are under discussion in mediation. So that's one thing that we have to try to find out, and try to figure out how we can actually make this a comfortable session in which that person can engage and take and participate if we decide that they're able to do that. And I know when I talk to private mediators, I always suggest that the private mediators meet with the older person first. When I talk to centers, I suggest, and I don't know how you do it here, so I'm just talking now, that the mediator get there at least a half hour early, and that they bring that older person in. So if the person is going to attend, so that we can get a better understanding of what their level of capacity is. And one advantage of doing it on the same day is we can get an understanding of what their level of understanding is right now, because that can change. That can change with the time of day, it can change with medications, it can, you know, be dependent on a lot of things. And even if they don't remember your name a half hour later in the mediation, they probably, if they can participate in the mediation, they probably can remember or know that you are a person that they feel comfortable with, and that you are someone that they can kind of trust and engage with, even if they don't remember your name. So we now have 2 people here from the training that we did last week in Keller. 2 weeks ago was that in Kalamazoo. So this is going to seem repetitive, but so it's really our job to try to figure that out and figure out how we can accommodate them, not whether they can, how should I say that? Not whether they are able to participate, but how can we help them participate if they're going to be there. So some of these questions, in order to determine how we can accommodate them, what do they need in order to understand the conversation, to understand my role as the mediator, to understand everybody else that's involved in the conversation? What do they need to be able to listen to and comprehend? I mean, is hearing an issue, for example? Do they need to sit in where we seat them may be important? Is vision an issue for them? Maybe we don't want to, if it is, we don't want to seat them where they're looking at a bright window. What do they need to be able to listen to and comprehend the stories of other people? Do we need to slow that conversation down? Do we need to use very simple and concrete terms? How are they going to be able to generate options and assess those options? Do they need to have a support person there? It's good when it comes from the court, the case comes from the court, because you do have an attorney or a guardian ad litem there who can support them. What do they need in order to understand an agreement? Don't forget that these are people who have, if it is before before the court has made a determination on whether they need a guardian or not. And is that often when you get cases, is it pre-hearing, before the court has actually determined that they need a guardian, so the parties are deciding on who the guardian will be?
Yeah.
Yeah. So don't forget, no court has determined that they are legally incapacitated. That means they can sign an agreement, right? And they should. If it comes to you after a court has made that determination and that they are a legally incapacitated person, I would never keep them from signing an agreement. Because that's a little bit insulting to an adult, I think, to say, oh no, you aren't able to sign that anymore. So I let them sign it, but make sure that they have a surrogate there, a legal surrogate, an attorney or someone, or a guardian who is legally able to sign for them.
How does the court make a determination as to who the guardian ad litem should be, or who the attorney should be? The reason I ask it, I come from a jurisdiction where those appointments are political.
So I'm gonna let Juliet answer that question. What's done locally here, how does it, I mean, the court has a roster, right?
Yeah, there are people who have been trained by the court to be guardian ad litem. And it's not a closed roster, you can be added at any time, but basically, the people who volunteer and are trained are the most likely to be picked because the court has confidence in that process. As for the attorney, I think it's similar, but basically, the network of people who comprise probate practice, those people are known to the court, and those people who would wish to be appointed as attorney are known to the court. So, again, it's not a closed roster, but it's not the world's largest list either.
Yeah.
And they're not
So,
paid
I
very
mean,
much too, right?
Pardon me?
They're not paid very much.
They're not paid, and
Yeah,
that's,
so it may
you're
not
right,
be
and
so
so
political
that's
to make
that's
it
somewhat self-limiting too, because it's paid, the fees, unlike in other situations, are paid out of the probate court fund. There's a fund for it. It's not a huge amount.
In my experience in this county, you wanna have those attorneys there. The guardians ad litem or the probate attorneys are really good, and they understand their client or the ward, and they're very supportive of families, and they're also supportive of mediation, and that they know they're great to use as a resource. When people, for example, if people are talking about other alternatives, and no one in the room knows what a trust is, or no one in the room knows what a representative payee knows, they're great resources to answer those questions. They're also great resources when we can see some things start to happen as mediators that could get things into a little bit of trouble, when the wheels start to kind of come off. It's great to be able to turn to those attorneys. What do you think?
Yeah, I would echo what you just said. We tend to see the same people, both in terms of the advocates and in terms of the guardians ad litem, and we were able to form our own opinions as to their trustworthiness and competence. And in general, I think the quality is very, very high, and these people can be very helpful to the mediators in terms of working through the kind of problems we see.
Yeah.
Susan?
Oh, sorry.
I wanted to go back to the family issue and enhancement of parties' capacity. And if it becomes clear to you that the party does not want a particular family member, how do you handle that?
Right. I've actually I have never had that happen from the older person, that they don't want a particular family member there. Other family members will say that sometimes. Siblings will say that, or blended family members will say that. Contradict me, those of you who've done these cases, if you've run across a case where the older person doesn't want their family there, but
Or
they may
a
not want
particular
spouses
person.
there, they may not want some of the spouses, but
You're right, I think you're right. I think it's family members that project onto the older person and say, oh, she doesn't want so-and-so there, but
Right.
it's not. the
So,
way
I mean, my question, I think, Carm, you can say how you answer these questions too. My question for them is, does this person, if it's a sibling or someone, does this person have the ability to kind of blow up things afterwards if they're not part of the conversation, and if they don't hear the discussion, and if they don't hear why these decisions are made, because they may have full rights to go and file their own petition for something else. So would it be better to have them there or not? I mean, and the flip side of that is the family member that says, I can't stand to be around my family, I don't wanna be there. So my question for them is it okay with you then any decision that the rest of the family comes up with, is that going to be okay with you? Or do you wanna have input into it?
Yeah, oftentimes it's a judgment call. I do the intake, and so I try to maximize all who should be participating in the mediation session. And then as I complete the intake with each party, I can get a sense of who should be there, who want to be there, who may not want to be there, and what other family members may not want particular people to be there. And so once I've sorted all of this out, then I establish who will be participating in this mediation session. And there's always the issue of the incapacitated individual as to whether or not, especially if they have Alzheimer's or some dementia, whether or not they can function in a mediation session. And what I normally do is talk with the incapacitated individuals and get a sense myself as to where they are in all of this and their ability to participate. For instance, next Tuesday I have a horrific blended Eldercare family situation where it involves an elderly couple who had previously been married, but they divorced their first spouses to marry one another, and the father has 10 children of his first marriage. The wife has 6 children of her first marriage. And so there's a long history of the two families trying to blend and a lot of contention and whatever. And so now this case was referred to me by attorneys who I've known for several years, and what they proposed was that this family come into mediation because there are issues about money, accounts, and stealing and caregiver responsibilities and a whole range of issues that you listed in your presentation. And so I think all of those issues were hit in terms of this particular family situation. And so the attorneys advised this family that it would be too costly to take this into court. And so we were able to narrow the participating family members to 2 biological children of the father, 2 biological children of the mother. And I will, on Monday, be talking with the parents, the husband and wife, because a lot of times when you're dealing with elderly people who have Alzheimer's or whatever, there's a lot of anxiety, and so I normally wait until the end after I have identified who will be participating to really talk with them, because otherwise they get real anxious, and then the caregivers have issues because they're all concerned about, well, what's going on here? Where are you taking me, and this sort of thing. So I usually wait until the end to do that and work out what their participation will look like. And obviously for this family, it's going to be a limited participation on the part of the parents, because the father also has some memory issues, but also has other physical and health issues. So they can't stay for the entire day, which this mediation will probably take. It'll probably run into multiple sessions as well. And so we're working the logistics in terms of that. So it gets very complicated, even in terms of sorting out who is to be at the table.
Do you share all that with, are you present during the mediation to share all this
I'm
information?
there, I'm not in the room,
Okay.
but I'm in the vicinity.
Okay.
But I do intake with everybody who's participating. And that can get to be really horrendous. I had a few years ago where there was a probate mediation where there were 20 participants. So you can imagine the amount of time it takes to conduct an intake with them, try to sort things out, because it can get really crazy. As many of our family mediators know, when I send out announcements, I get these responses, oh my goodness. So, yeah, they can be quite difficult.
So this is really more of the same, what are the physical accommodations, everything's there, support people. Is that person a necessary party? These are all things we were just talking about. This is really, if you do a mediation that is not a court case, which I don't think you do very many of here, so it's just, you may decide that if you are doing a case like that, the person needs a support person, and I would just leave you with a thought that one of the family members at the table is probably not the best support person for them, someone who's engaged already in the conflict. So this is a list of people that we have used. I think you're gonna email this out, right, the PowerPoint?
Okay, yeah.
Okay. I have a little bit of some problems that we can work on here. Three of you, this will seem very familiar too, who just took the training. So I'll give you a few problems and you can just discuss with, or we can look at it as a group and we can just, why don't we just do that as sort of a fishbowl and tell me whether there is an ethical dilemma. So an ethical dilemma is when one of the values of mediation come into conflict. So values of mediation like confidentiality, neutrality, people who, that it's about needing to be there to make decisions as, nothing about me without me kind of thing. That person, having all the necessary parties there to make the decision. What are some more of those values? I have a list of them. Voluntary, non-coercive, confidentiality issues, things like that. So, decide if there's even a dilemma in this, and then if there is, what is the dilemma? And I'm gonna go, we don't have time to do all of them, so I'm gonna just look, here's one. So you're mediating a situation involving two brothers and a sister. The sister's living with the mother in the mother's home, and there aren't any attorneys at the mediation. During the mediation, the siblings decide that the sister, who's living with the mother, should become the guardian and should get the house in order to pay her for the care she's giving. Is that a dilemma for the mediator or not?
You told us earlier that guardianship has to be done by the court, but
Right.
people can't just decide. So
Right.
presumably the court would approve if they were all in agreement.
Right, so that's the problem, right? I mean,
Well, the mother.
they can't make that decision,
Right.
right? So then, maybe you could write something up saying that if the court decides, then let them know they need to go file a petition for that, this is who we want to be the guardian. Are there any other problems?
Well, without the mother being a party, this can't happen.
Right? Why?
Well, because she hasn't been determined to be incapacitated, or
Right.
not have capacity, and even if she's found to not have capacity, the getting of the house is problematic without a guardian ad litem, because that, there's the person who's the trustee is taking monies for unclear purposes. You almost need a separate person to handle the finances.
Right, so
If that person's living
it's
there.
her house, she lives in her house, and so they're basically giving away her property, right? That's a problem. she might have a will, and that's gonna go to, that house may be going to somebody else, and you can't change somebody's will, without their, I mean, they're the only one who can change their will, right? So that's a problem for the mediator. What should the mediator do? Also, there's another issue, and that's that it gets more complicated, but that's, you're actually transferring property, and if she's eligible for Medicaid down the road, this could disqualify her for that, so, because there is a look-back period for Medicaid. So all these things get pretty complicated for them. So what should the mediator do?
So, since the mediator isn't supposed to give legal advice, should the mediator not suggest that they consult an attorney?
Absolutely. Right. And the mediator can go so far as to say, you know, I can't write this up because this involves a lot of legal issues. And so you should probably go, I would recommend you go to an attorney to do it. Now, they can probably go outside and make their own agreements and, you know, whatever they want to do, but, and they can make their own agreement after the mother dies, who gets the house, no matter who's in the mother, they can make a trade. But it's not something we can write up as a agreement.
In Sri Lanka, they have a, I don't know if it's a rule or it's just an understanding, that the youngest son in the family marries a woman who will take care of the parents, and then they will get the house.
So that's very simple.
No longer.
That's something that was reluctant.
Cultural differences.
Yeah.
Here's another one that is, you're mediating among family members about appropriate payment to Mary, who's providing care to the father. The father is part of the mediation. A year ago, Mary and her family agreed she should get free room on board in exchange for the care. Mary then said that she realized that if they hired a professional or an agency person, that person would be paid more than she's being paid. And so the other 5 siblings said, no, you made a contract, you should be held to it. But then they sort of figured out a way around it and decided that if they could pay Mary they could pay her as a gift from the parent instead of wages, and then she could save money on taxes, right? And then she would still she'd get more money, more comfortable than she get from an agency. Is there anything wrong with that for the mediator?
Sure.
Is that a problem? Is that a dilemma?
It would be for me, because I wouldn't agree to an agreement which was illegal, essentially.
Right. And why is it not legal?
Because they're really paying her for services, but they're paying her under the table for services.
Right. Paying into the table. So it's a way to avoid paying taxes, and that's not something we want to do as a mediator either, right?
In real life, this happens all the time.
Oh, yeah, they'll go right outside
They
and do
don't-
the same thing.
they don't go out
But
and
I'm
get
not
o-
gonna write it up as a
Yeah,
mediated contract.
that's what I say.
Oh,
This
yeah.
could be one of these cases where you say, well,
Yeah.
that's what you
It's
want
very
to do.
common, and it's very common that it would come up in mediation because of that, because it does happen a lot, yeah, I agree. This is one, this was a piece I did. The father has advanced Alzheimer's and he's not in mediation. In a private session, the caregiver tells the mediator that she's planning to take their father on a gambling trip to Las Vegas. She also had power of attorney, so she can control the money, by airplane. Because she said Daddy never liked to fly anyway, she thought the trip might be a little rough for him. And it became pretty clear to the mediators that she was taking her father on a vacation as a means of paying for her vacation out of his money, right? But it wasn't, this was in caucus. It wasn't clear she was gonna tell her siblings anything about that. So, did we have a dilemma on our hands? So what was the problem with that? What was the value of mediation that was in conflict with that?
Is it one of those abuse, neglect, exceptions?
Yeah.
Yeah, yeah.
The reporting thing, yes.
It's certainly not his idea, and he's never liked to fly. So it's, it's doing something quite reckless with him and his money.
Exactly. very reckless. It was actually financial abuse as well as emotional.
So how's that work out?
And this was in a home in Ypsilanti. He was living at home with a family, and he was actually there crawling around on the floor in diapers. That is how advanced he was.
Should have checked him on the plane.
Right, and he was always afraid to fly, which maybe he wouldn't be now, I don't know, but it really seemed,
Not much of a vacation.
no, and where was he gonna be?
There's also a confidentiality issue because really the other siblings should know too, and you can't tell them, but wouldn't you have to suggest that the other siblings be involved?
Yeah, well, I mean, it's a confidentiality issue in that it is an exception to confidentiality. It's a reporting issue that I would need to report abuse or neglect.
So that comes with.
Right.
There's no confidence in the discussion when she says she was abusing and neglecting the
Right.
finances of the individual.
The fact the siblings aren't included is a minor issue at that point.
Right, and unfortunately, the GAL was there and actually caught wind of it, when pretty soon as we were thinking we need to end this, and, so, that, ended that.
Who would you report it to?
I'm trying to think if this was a center case. If it was, I would have reported it to the center. This was a long time ago. It was me and Susan Carter. But if it was a private case, then I would report it to Adult Protective Services.
Okay.
I was just gonna say something about that. You were talking, I said, that's abuse. This is part of my duty. So you answered.
Yeah, right. Well, yeah, not the mandatory reporting statute, because I'm not a mandatory reporter as a mediator or as an attorney, but you are of a profession that you have to. Under our confidentiality rule, 2.412, we need to let parties know on these cases. That's why it's important for us as a mediator to let parties know, and you have it in your consent form for the center, that, any allegations of abuse or neglect of a vulnerable adult or a child may be reported. So,
It's very clear that the daughter had no clue that this was abuse, to me. So she, no, I mean, it's like she had
she
in her
had power of
head.
attorney. Does it say guardian here?
Yeah,
This is the caregiver.
the caregiver. But it sounds like she didn't have a sense that this was something that she would be abusing her father about. And then if you as a mediator reported to whomever, she's probably taken totally aback, well, gee, this wasn't something I even thought of. Is there any way the mediator can address this to say something in terms of raising awareness as to what is abuse and what isn't abuse, or what is sort of.
Say something to her.
To her, I mean, is there a way to do that that's a reasonable thing, instead of doing a reporting that all of a sudden exacerbates the whole conflict of the family?
The personality of this person, I mean, yes, I could say that to her, that it's abuse. The personality of this person, I had a feeling it would not have mattered had I said that. She was, I just told this story in the training, I'm sorry, I apologize. She had power, she was handling his money. She had a brother who was actually living in the house caring for her father in that
Oh, so she
situation.
was just totally.
And the roof was leaking, and the roof was leaking on the brother's bedroom. So, when it rained, he got wet. And she said, it's not raining on my dad, it's raining on my brother. I'm not gonna do anything about it. So she wasn't gonna pay for, I had a feeling that it might not have mattered to her if we had talked to her. Some people it might, but, I think when you are thinking about putting a person who's crawling around on the floor, that far advanced in dementia on a plane so that you can go on a gambling trip, you're not thinking, and whatever I said might not make a difference.
No, I agree
But
with that.
in other situations, yeah, you certainly.
I think sometimes, like we do in sort of special ed and stuff, we look not only with the child, we look at the parent, and sometimes there's a continuum of disorder.
Yes, certainly, and that's sort of our judgment call in private mediators, whether that could be helpful or not.
because we transport mom back and forth.
Right.
And so we use mom's funds to purchase this. We need an extension on the house because mom's living with us, it's a little too cramped. So they start to make purchases that they justify in their minds as being part of this person, and yet they dissipate the estates. And I think that in the mediation, it's, and again, you don't wanna give legal advice, but there's breaches of fiduciary duty that are occurring within the mediation. And I don't think they've rise, you know, in some cases to contacting adult services, but clearly rise enough that, if that person doesn't add a guardian ad litem in the mediation, I don't know what, I mean, I would think that you might wanna halt the mediation and then, perhaps have a person appointed as guardian ad litem. We had one in the ERC where, it wasn't as bad, but, the parties agreed that there would be an outside financial person helping the person who was overwhelmed taking care of mom with some of the decisions about finances, so that she wouldn't be caught in a breach of fiduciary duty.
Right. Yeah. The thing about money and siblings mistrusting another sibling that's handling the money, and whether it is because they don't want that sibling getting more than they're getting, or whether sometimes it comes out of a real concern that if that sibling dissipates the funds, mom's gonna need care later on. I'm probably gonna then have to start paying for her care because she's given, you know, all this sibling's taking all her money. You know, the mom, sometimes the parent is giving one of their children money that is not as well off as the other children, and that is, you know, that's their ability to do that. A parent can make those decisions. But as that person gets older and needs care, it starts to make, if that person's living with them or on a joint checking account with them, it can make the other siblings very suspicious and very angry. And also, I've had cases where that fear that mom's giving all her money to my sibling, and you know, she's getting older, she needs care. I'm gonna, you know, because I have more money, I'm then gonna have to pay for her care, and then she's gonna continue to keep giving her money to my sibling, and if I wanted to give money to my sibling, I would.
I just want to add, as a footnote, I think these dilemmas are pretty clear. There's some real clarity of abuse and neglect, but there's also a fair number of cases that have multiple siblings, where there's this accusation, suspicion that one sibling is gaining financially or gaining something from the parents that they're giving care to, and there's no abuse or neglect. These parents are able to make the free decision that you're the person that's running all my errands, going to the doctor's appointments, I'm gonna help you get a car or whatever. And so sometimes that mediation does spiral into things that happened 2 decades ago because these siblings did not like each other. I have at this center experienced cases where 60-year-old women were mediated about their 85-year-old mother, and they started talking about, you took my boyfriend when we were 16, 17 years old, but that resentment lasted, and one of those siblings happened to appear to be gaining. She lived on the property, she had a little bit more of mom's assets or had access to it more so than the other sibling, and all of a sudden it wasn't about mom at all, it was about the unresolved issue from being teenagers and the perceptions of who mom liked best and all of that. So I just want to make it clear that sometimes I don't want us to be alarmed every time we see an imbalance that one sibling is getting $1,000 more than another sibling, or getting some compensation or gift every month, that it's becoming an abusive situation. Sometimes it's just unresolved stuff from the past.
Right. And so the best thing to do, actually, you have the luxury of just taking it to the center and letting the center decide if you are concerned about abuse.
Well, I think as mediators, you have the use your caucus, use techniques to try to dig deeper to understand. Of course, if it is, an abusive, neglectful information situation, then you can come to the center staff and we'll deal with the reporting, but don't be alarmed and jump to that conclusion without exploring it a little further.
Yeah, that's right.
So the reporting comes after the mediation's concluded, like would you carry out, would you allow the parties to sort of get into agreements if you think that,
and then go and report something?
Yeah.
No, I would stop the
You'd
mediation.
stop the mediation
If
if there's
I
any-
would, I mean, again, you have the luxury here to take a break, go talk to the center staff and figure out with them about whether it is something that needs to be reported. If they don't think it does, then, you can go right back and do what finish up the mediation. But if it is something, then I think you need to withdraw from the mediation in whatever way makes sense. You do not wanna, if there is someone who is emotionally or physically seriously abusing the person in the room that they're gonna go home with or something, you don't wanna say, I'm gonna have to make a report because of something that was said here, because they're at risk after they leave. But if it is something, if it's a case where you're not concerned about that happening, you may say, I mentioned in the confidentiality statement that this is an exception, and we decided we need to probably let a professional make a determination about this in order to protect you. So, or if you just have to withdraw without saying anything, you can just say, I just don't think that we can make any more progress here today.
And utilize the staff, that's why we have them available when you're mediating, talk it out, use the staff as your sounding board, talk it out, and then if you have to exit or terminate that mediation, you can come up with a game plan that makes sense, because we don't want to compromise the safety
Right.
any further for that ongoing person.
So things that are different about these cases, multiple parties, family dynamics, questionable capacity of a person to participate, all the other stuff that swirls around, and then some of these sort of tricky little ethical things that you can get into make these cases a little bit more complex. And just going back to the family dynamics issue, I can remember a case that I did where it really does, this goes back to what Belinda was saying, but it really does seem like these people are not in their 50s any longer, but they're around age 10 or so. I can remember one case that I walked across the room to get something, and one of the siblings said to the other sibling, "You're a liar." And the sibling said to me, "He just called me a liar." and I turned around, and before I could say anything, he said, "Did not." She said, "Did too." And they went back and forth like that till I said,
So what did you do?
I just
We've
said,
had that
well, I
situation
just
too.
said,
I
you
don't
know,
know how to solve
the
that.
ground rules, all that other stuff, in which case he challenged me and said, I don't think liar is name calling, so. Yeah, discussed that for a while. But, you do really, and these are people in their, 50s, 60s. Okay, this is just a real quick thing, I'll go through it very quickly. I've done this with another judge, Judge Mack in Wayne County. It's a good way for you to, I know I'm preaching to the choir on this, but for you to see what a court decision is like, as opposed to I know you know what a mediated decision looks like, but what it looks like compared to a court decision. So, this was a conservatorship, and it was an elderly woman who was in a nursing home, and the brother was paying the bills, and he wanted to become conservator because he was trying to pay the bills, but the bills weren't always getting to him, he wasn't finding them, and so on and so forth. And she just had such a strong sense of dignity, she did not want him to be a conservator. She didn't want somebody over her controlling her money. And so, she was opposing the court petition, so we mediated the case. So the question is, the legal question, the court's gonna decide, does she need a conservator or not? And likely she does. She had dementia, she was failing, and bills weren't getting paid, so the court would have appointed the conservator. Now, for her, that would have only made her more angry and upset, right? In mediation, they really came up with the same agreement, except she got some spending money, but she made the agreement. So when we talked to her about what her interests and needs, it was a matter of personal dignity, She admitted that she couldn't really keep track of things and that she didn't really object to her brother handling the bills. Actually, when we talked about it, that made life a little easier for her. She wanted some spending money so that she could go to the vending machine and the beauty parlor and things like that. She had no spending money. He didn't want to give her spending money because he said she'll just lose it or it'll get stolen here. And so she spoke up and said it was her money. She'd earned it. And so when we talked about it, there was $60 left over a month after her bills were paid. And he agreed to give her $15 a week to lose or spend or do whatever she wanted, and that she agreed to have him become conservator. So, end of story. Now, the court would have put him in place as a conservator too, but it would have been a very different result for her. She would have felt very differently about it, and she got her spending. She did say, he said, what do you need money for? She said, I might want to go out on a date. This was 4 children. This was a full guardianship, and she had advanced dementia. She had 2 daughters taking care of her at home. There were 2 sons. I think it was actually a blended family. I'm not sure though. Her 2 sons were not allowed access to the home, but one of the sons was a co-guardian already with the daughter. So the daughter, one daughter and one son was a co-guardian, but the sisters wouldn't let the brothers in the home. So she wanted, the sister petitioned to have him removed as co-guardian. And then the sisters were upset that they were having to do all the work, although they weren't letting the brothers and family into the home. And they also instructed the paid caregivers in the home not to give any information to the brothers about the mother's condition or anything. And one of the brothers was a guardian, he needed information. And then they accused the brothers of taking family property out of the home, which is why they were denying them access in the first place, because they thought that the brothers were, and their families were stealing stuff out of the home. And they took all the photos and reminders of the brothers out of their mother's room, so that she would no longer know she had any boys. So the judge Max says, the legal question would be whether to remove the brother as a co-guardian, and an additional question would be whether to remove the sister for failing to carry out her duties. He would keep the brother as the guardian and remove the sister who was living in the home as the guardian. So he was gonna, that would force them to try to get along, right? But we all know. So in the mediated agreement, they actually wound up remaining as co-guardians. The agreement was that the brothers and their wives would have access to their home, the siblings could remove any of their personal property by just as long as they gave notice.
I'm sorry, we can't hear you back there.
All right, you
We
can't
can't hear you.
Oh, well, what's the matter here?
When you turn toward the wall, it goes away from the mic.
Well, okay. Can you read it?
Yeah, we can read it.
No.
It'll pay us to come listen.
They agreed to give them access to the home. They could remove property as long as they gave warning ahead of time. The co-guardian would be able to make decisions about medical issues. They agreed to keep a log in the home where they would write down things that happened when they visited for each other. And they agreed that the brothers and wives would actually do the buying of groceries, and then the sisters and clothing and medications, and the sisters would keep a list of things that were needed. And if communication broke down again, they'd return to mediation, and in the end, they hugged everyone.
Susan, in these cases, when they're appointed, guardians are appointed by the court, they require an accounting to be filed in these?
Yearly.
Do they require what?
A financial accounting.
Yes. Yes, the court requires that, yes.
Do they enforce it?
Yeah,
Yes, yeah.
and medical care and everything like that, so if you're a guardian, you have to say what medications are in every year and give a little report.
And the last one
So
is.
doesn't that,
just in a state case,
address a lot of these
United-
problems?
Oh, sorry.
I was gonna say, I thought that would address a lot of these problems of he's taking this, he's not doing that. That the accounting, it would come out in the accounting.
Right, except that just the, let's say the brother would have remained as co-guardian would have remained as guardian. The court would have removed the sister as guardian. Sisters lived in the home. They hated the brothers, or they didn't at that time like the brothers, shall I say. They were removing the pictures of the brothers from the mother's home. So all of those things got resolved in mediation. And they figured out a way to cooperate and that everybody could help each other out, and none of those things would have happened in the court. An estate case, stepsisters, deceased father, different marriages, pieces of personal property, so this is after the father was deceased. Accusations about who had, stolen the garage door opener and taken the car, and various personal items. The court in this case would have appointed a professional or an attorney, a public administrator to handle it and divide up everything. They still wouldn't have gotten along, right? And so in mediation, they worked out everything. All of the items that were supposedly lost were actually accounted for. The father had actually given some of those things, and everybody was happy in the end. Same thing. But that's just to give you a quick snapshot of how a court makes a decision. It's just on the legal issues. That's it. And we can do so much more.